Well, good morning. I'm Jaginder Rana. The topic of the discussion today is third party motor insurance claims. Third party motor insurance claims. Driving in India without third party insurance is illegal and can result in financial burdens if caught without a valid policy. However, even when you have a TP cover or third party cover, there may be instances where your third party insurer may refuse to cover damages and injuries caused to third parties by the insured vehicle. See such conditions and the resources available under the number of times you can avail yourself of the third party motor insurance. Usually, if you and your vehicle are involved in a road accident which has caused extensive damages to someone's property or life, insurer is liable to pay for all such injuries or destruction. But the question is, how reliable is your third party insurance policy? There might be instances when your third party insurer might not honor any claims that have been made against your policy. So by the third party, that is victim, and this is despite you having a valid TP motor insurance. Due to this, you could end up paying a hefty amount out of your own pockets as compensation to the affected party. There might be instances when your third party insurer might not honor any claim that have been made against your policy by the third party victim. And this is despite you having a valid TP motor insurance. So due to this, you could end up paying a hefty amount out of your own pocket as compensation to the affected third party. Now let us know about the insurance instances where your third party insurer may step back from paying for damages and if you can avoid such conditions. See, what is the third party motor insurance and when it can be denied? The idea behind this insurance cover is to offer protection and compensation against damages caused by the insured vehicle, that is your car or bike, to a third party on the road. So which could include pedestrians, another car and its occupant passengers. The policyholder, that is you or the concerned vehicle, are not eligible for any coverage under TP insurance. Now TP cover doesn't work if premium is unpaid. Means if your third party motor policy is not active, that is, it has lapsed due to the premium non-payment before or at the time of the accident, your insurer can deny claims under the third party insurance. Then driving car under the influence of alcohol or drugs. If the driver is found to be under the influence of drugs or alcohol, this may become the ground for rejection of the claim. Other conditions under which your TP insurer may refuse to honor claim is if you have been found driving under the influence of alcohol or drugs and not having a valid license or driving for wrong purpose. If you are not having a valid license, can also be ground of rejection of TP claim. If the person driving the vehicle did not have a valid driving license or was found using the vehicle for purpose not covered under the policy, for example, using a private car for commercial purposes, the TP insurer may refute any claim. So for the claim to stand, your driver's license should be active and not expired to be valid, while a learner's driving license is legal. It is mandatory for the learner to be sitting beside an experienced driver who also has a valid regular license while driving the vehicle. Also, the learner should have an L sign painted at the back and front of the vehicle. If someone with just a learner's license is found breaching either of these two conditions, the tip insurer is well within its right to refuse to pay compensation. Then not having a valid fitness certificate. The third-party insurer can refuse to pay if the damage-causing vehicle does not have a valid vehicle fitness certificate. Notably, a new private vehicle's fitness certificate is valid for 15 years, after which it might be renewed after 5 years. And if the policy is under grace period without premium payment, in motor third-party insurance, there is also no provision for a grace period. So hence claim will only be admissible if the policy is active and valid at the time of the incident. Now the question is, what happens if the premium check bounces? In a 2022 judgment, the Karnataka High Court had mandated that the insurance company would be liable to pay compensation to a third party, even if the check issued towards premium payment by the insured was dishonored, if the same had not been properly communicated to the policy holder before the accident happened. And then paid amount can be recovered by insurer in case of violations. Even when the insurance company pays the claim, but later discovers any violation, then it can recover the amount from policyholder. In cases where the insured violates the terms of the policy, the insurer may honor the third-party claim, but then recover the amount from the insured. This is known as subrogation. So, however, there is still a recourse left to policyholder if there are disputes regarding the insured's violations. The matter may be taken to the motor accident claim tribunal or a competent court. So, the tribunal or court will determine the liability of the insurer and the insured based on the evidence and circumstances of the case. Now, how many times can third-party insurance be claimed during the lifetime of a vehicle? So there is no limit on the number of third-party claims that can be made during the validity of a motor insurance policy. Means each time a vehicle is found to have caused an accident resulting in injury, death or property damage to a third party, the affected party can file a claim, provided the incident occurred within the policy period and the claim is within limits. So generally all motor policies are issued for a year and need to be renewed every year. However, new two-wheelers are to be compulsorily insured for 5 years against third-party risk, and private cars are to be compulsorily insured for 3 years against TP risk. So per legal auto claims team, so if the TP risk, so if the same insured vehicle causes property damage or injury to third parties multiple times, the insurer is obliged to settle each legitimate claim as per the terms and conditions of the policy. So third-party insurance operates on an incident-based approach rather than a lifetime approach. And the premium payable for third-party insurance as per IRDAI is, say for private car, not exceeding 1000 cc. 1 year policy 2094. Long-term policy 6521. Private car exceeding 1000 cc but not 1500 cc. 1 year policy is 3460, but long-term policy is 10640. And the private cars exceeding 1500 cc. 1 year policy means 7897. Long-term policy means 24,596. If in case the car is private electric cars and the policy is for 1 year, then not exceeding 30 kV, 1780. Long-term policy is 5543. Exceeding 30 kV but not over 65 kV, 2904. For long-term policy 9044. exceeding 65 kg. 1 year policy 6,712. Long term policy 20,907. So this is as per the IRDA order dated 4th March 2022. Now, is there a monetary limit on the damages to be paid by the TP insurer? For property damages, which includes other parties' vehicles, buildings and more, the limit is up to 7.5 lakh. In case of bodily injury or even death, the coverage for third parties is unlimited. This also covers the medical expenses and compensation for injuries sustained by the other party in the event of an accident. Our experts have divergent views on this. Rupees 7.5 lakh limit had been eliminated under amendments made in the Motor Vehicle Act in 2019, meaning that there is no monetary limit under third-party insurance for property. Regarding coverage for damages to properties, the insured can choose from two options. One is limited third-party plan and the other is normal one. So it is important to remember that even under a limited third-party plan, the coverage for bodily injury or death remains unlimited, that is without any monetary ceiling. Under a limited third-party plan, the property damage is defined up to Rs 6,000. This means that the insurer is only liable to pay for property damage up to Rs 6,000. The compensation for damages above this limit will have to be borne by the insured themselves. So the premium for such plans is generally cheaper by around ₹100 than the regular. Now the individuals who are considered as third party, who are they? Imagine that Mr. A is driving his car. Sitting alongside him are 4 of his friends who are unrelated to him. The car meets with an accident, causing the death of 2 of the car passengers, Mr. B and C. So along with causing significant damages to another party on the road, will Mr. B and C also be liable for compensation under TP insurance? In this case, the passengers will not be eligible for any compensation. Because third-party insurance, as mandated by the Motor Vehicle Act 1988, is specifically designed to compensate third parties, means pedestrians, other vehicle occupants, or property owners, so who suffer injury, death, or property damage due to insured vehicle. However, the insured has opted for an additional cover, such as personal accident cover for unnamed passengers. The harm caused to the occupants of the insured vehicle may get covered up to sum insured of Rs 2 lakh. There are a couple of insurers who have now started offering an enhanced personal accident cover for passengers, which the insured can opt for. A recent mandate by Rajasthan High Court under the bench of the Justice Nupur Bhatti has also affirmed that in the case of a private vehicle insured against the Act only policy, the insurance company is not liable to compensate the occupants of the vehicle, since they are not considered to be the third parties as required under the Motor Vehicle Act 1988. But previously, in the case of the United India Insurance Company Limited versus Karamchand and others in 2011, the Jammu and Kashmir High Court had established that third party includes all those who suffer as a result of the use of the said motor vehicle in a public place, which includes occupants of the vehicle or even any other persons traveling by road or in any other vehicle who fall victim to the accidents. So all these individuals are eligible or liable to be awarded compensation as a result of such an accident. I repeat, United India Insurance Company Limited versus Karamchand and others 2011, the Jammu Kashmir High Court had established that third parties include all those who suffer as a result of the use of the said motor vehicle in a public place, which includes occupants of the vehicle or even any other persons traveling by road or in any other vehicle who fall victim to the accidents. So all these individuals are liable to be awarded compensation as a result of such an accident. Thank you. Thank you very much.